Welcome to AHA session powered by lawyer.com. I am Vinayak Srivastava, Advocate, Delhi High Court. I've been into litigation, arbitration, and dispute resolution for more than 11 years of experience. Now, coming down to the questions, the first question is that what is the scope of private mediator to resolve disputes between disputants? Well, the role of private mediator is rather limited when we compare it with the other dispute resolution mechanisms. One is, of course, a regular court, and the second is an arbitrator. In case of mediator, the mediator requires, in order to give any decision regarding any dispute, he requires the consent of both parties to the dispute. Even if one of the party objects to the decision given by a mediator, the mediation will fail. The role of mediator is to give sustainable solutions which can be acceptable to both the parties, and if any solution is acceptable to both the parties, then that can become has a decree of court. That can become a decree of court. The second question is mediation and other ADR methods for settling trade disputes with pharmaceutical companies. Now, the arbitration as a dispute resolution have been used by private sector for more than 20-30 years, and it encompasses to all sectors. And in case of pharmaceutical products, pharmaceutical companies, the major arbitration disputes comes in the era of IPR disputes, because pharmaceutical companies invest a lot of money in research and development for their pharmaceutical products, and the disputes can come with their vendors in case of breach of confidentiality. The disputes can come even from their employees who can breach the confidentiality clause in their employment agreement. So, in these cases, the pharmaceutical products, we have been seeing a trend that pharmaceutical companies are actually using arbitration much more rather than a regular court mechanism to quickly solve their disputes, because arbitration in a way has an advantage of being, there is a time limit to resolve the dispute. For an arbitrator, he has to give a reasoned an award within 11 months, and if there is any increase in time limit beyond that, then he needs to give reasons for that increase of time limit. So it's a quick mechanism, and arbitration is a quick mechanism, and it gives a good reasoned judgment should be good and reasoned, and I believe it's the most effective way of resolving disputes between the companies. The third question is an arbitral tribunal really entitled to jurisdiction? Yes, arbitral tribunal is mandatorily has to give a reasoned judgment on its own jurisdiction. Under Section 16 of Arbitration and Conciliation Act, any party to dispute can raise a plea of jurisdiction on the first instance, that means on the first date of hearing itself, and the arbitrator or the arbitral tribunal has to give a reasoned judgment on its jurisdiction, and then it can proceed with the matter. That is option number one with the arbitrator. The second option for the arbitrator is that it can wait till the finality of the case, and along with the award, it can give the judgment on its own jurisdiction. Of course, that the judgment on its own jurisdiction, if any party has any objections on it, we can file the objections under Section 24 before the court. The last question is that is there any real decline in the idea of arbitration in the area of administrative dispute resolution? Yeah, I don't see that, because there is no decline. In fact, when we say about Indian context, in fact there is the Indian government is in fact using ADR mechanisms much more now than they used to before, when we say 5-6 years before, because they have seen the experience of the private sector, how effectively they've been able to resolve their disputes, and the litigation costs for these companies have come down So government authorities want to really reduce their litigation cost also, and want to resolve amicably these disputes, administrative disputes can be. So the Indian companies, especially the Indian government companies, Navratnas and everyone, and Indian government authorities, they are including the arbitration clause in their tender documents for any procurement they do with the vendors or anything. So in case of any dispute, it goes to arbitration. So in fact, in Indian context, there is upheld trend rather to use arbitration for resolving government-related disputes. So thank you very much. Thank you for giving us an opportunity to present. In case of any other questions, you're free to call us and give us your feedback. Thank you very much.